So first I'd like to acknowledge that I'm joining you from the lands of the Wurrung and Boonwurrung people of the Eastern Kulin Nations, and acknowledge that sovereignty was never ceded. And indeed, as we discuss queer struggle and oppression today, I want to express solidarity with the First Nations people of the world and the deep knowledge embedded in First Nations cultures. As Ted mentioned, I'm Dr. Drew Pettifer. I have the honour of introducing someone who really needs no introduction. So the Honourable Michael Kirby, ACCMG, is an eminent international jurist and educator, having been one of the longest serving judicial officers in Australian history. He retired from the High Court in 2009 after 13 years on the bench, twice having served as acting Chief Justice. He was the first openly gay person to sit on the court, and prior to his appointment to the High Court, his roles, which stretch back to the 1970s, included positions like Deputy President of the Australian Conciliation Arbitration Commission, inaugural chairperson of the Australian Law Reform Commission, Judge of the Federal Court of Australia, President of the New South Wales Court of Appeal, President of the Court of Appeals of the Solomon Islands. And after his retirement from the bench, he served on many international and UN bodies, remaining particularly active. These have included being a member of the Eminent Persons Group of the Commonwealth of Nations from 2010 to 11, Commissioner of the UNDP Global Commission on HIV and the Law from 2011 to 12, Chairperson of the UN Commission of Inquiry on North Korea from 2013 to 14, for which he was awarded the Order of the Rising Sun, Gold and Silver Star from the Japanese Emperor in 2017, member of the UN Secretary General's High-Level Panel on Access to Essential Healthcare from 2015 to 16, and since 2018 he's been co-chair of the International Bar Association Human Rights Institute. He has many, many awards, including the Australian Human Rights Medal, the International Gruber Justice Prize, and was the winner of the inaugural Australian Privacy Medal, among many, many others. I could go on, but I want to end by saying that Michael has a profound commitment to education, having served on governing bodies of many universities, including 9 years as Chancellor of Macquarie University. He's an honorary professor at 12 universities in Australia and overseas, and has numerous honorary doctorates. And we're very lucky to have him speak to us today at the University of Western Australia. His interests, according to his website, before I hand over to Michael, include HIV/AIDS and the global right to health, LGBTIQ, animal welfare, the arts, and good causes. Can we please welcome Michael Kirby?
Thank you very much, Drew, and thank you also to Ted Snell and to the others at the University of Western Australia who have made it possible for us to establish this link across our continental country and to talk about thinking queerly. I, like Drew Pettifer, acknowledge the Indigenous people of our land scattered all over the continental landmass of Australia and in Tasmania. And like Drew, I feel a link with the Indigenous people in that though small in number and a minority which has been subjected to legal rules that have been oppressive and unjust, we are beginning to see improvement and change, and it is the duty of all intelligent people, all rational people in Australia, to move in the direction of change. I also want to pay a special tribute to the University of Western Australia. I first came to the University of Western Australia in 1966 when I was participating as a student troublemaker in the National Union of Australian University Students. They had an annual meeting which was scattered around the country, and in that year the meeting was in Perth at the University of Western Australia, and I gathered there with some friends from UWA, Rob Holmes Accord, his future wife Janet, Darryl Williams, later the Federal Attorney General, and others, and we joined in what was for me the last meeting of NUAUS that I was attending. I can't recall to mind any of the actual debates that we went through at that meeting, but I can recall a wonderful opportunity that was presented to me unexpectedly when I discovered that in the Winthrop Hall there was a performance of the St. John Passion of J.S. Bach being prepared because our meeting coincided roughly with Easter. And I was not familiar with the St. John or the St. Matthew Passion, or indeed with much of J.S. Bach's music. And so when I look back on that time, it is a spiritual thing and a thing of the mind and the spirit, the music of Bach, that I remember from my visit to UWA at that time. And I will always be grateful for the encounter that was organized for me to enjoy J.S. Bach's wonderful music. And so on this occasion, we are coming together in a similar spiritual, emotional, and intellectual quest that I hope will be memorable for us all as we contemplate the reasons for and the cures of thinking and acting queerly, and make sure that people coming along today don't have the same difficult journey that many of those who are older have. Um, Subsequently, in my judicial life, I came to Perth virtually every year with sittings of the High Court of Australia, and I would come out to UWA, and later I would attend meetings of student bodies where I felt at home, that being the way in which I had spent most of my time in university at the University of Sydney. But one thing was very different, and it was the experience of coming to the entrance of the University of Western Australia and seeing a flag flying that I had never seen at any other university, and indeed I couldn't remember seeing at any non-gay events. Um, and this was the rainbow flag, and the rainbow flag was proudly flying as I, a Justice of the High Court of Australia, was entering into the grounds of the University of Western Australia. And I'll never forget the sense of emotion that I felt when I came through the entrance and saw the rainbow flag, and I thought, well, I wouldn't have seen that back in 1966. And the person who was responsible for the flying of the rainbow flag is Alan Robson. Alan Robson was the Vice Chancellor of the University of Western Australia from 2004 to 2012. So his period of service overlapped with my own service on the High Court of Australia. And I understand that Alan Robson is present at this occasion today. Now, Alan Robson has a wife, children, grandchildren, and he's absolutely overwhelmed with heterosexuality. But under his leadership, the University of Western Australia became the first university in our country that flew the rainbow flag. And I want to thank him for taking that initiative, and I want to thank him for his leadership in doing so. It probably lifted the spirits of many young LGBTIQ people at University of Western Australia. It certainly lifted my spirits, so much so that when I came through, I asked the driver to go around and go through the gate entrance again because I wanted to see it. And blink and make sure that I wasn't having apparitions. But there was no apparition. The flag was there. And I know from other universities in Australia where I have ever so gently suggested that they should fly the rainbow flag, as Alan Robson had done at the University of Western Australia. It isn't hard to get bureaucrats, rather, it is hard to get bureaucrats to take a step that is new, but it wasn't hard for Alan to do that, and it was a great initiative. Some universities have actually refused to fly the flag, though there is a flagpole ready for it. But it will happen, and it will happen because of leadership of people like Alan Robson. So I want to pay a tribute to him and express my thanks. What I want to talk about today is why it is that there has been in our country, still is in some parts of our country and some parts of life in Australia, and certainly is there in abundance in many countries, um, such an enormous hostility towards LGBTIQ people. Why is this so? What is it that causes this animosity? And it's that which I think brings us together to talk about thinking queerly and what it is about thinking and acting queerly that causes such animosity and hostility. Let there be no doubt that there's a lot of animosity and hostility, and the exhibition which is being displayed at the Lawrence Wilson Art Gallery um, of the wreck of the Zeewijk in 1727 is a very vivid tale, both of the dangers of travel at that time, but of the special danger of people who were caught engaging in gay sex. Um, Now, the wreck of the Zeewijk is famous for many things, not least the wreck, the circumstances that led to the change of course of the vessel that brought it into collision with some of the reefs that scattered along the coast of Western Australia. But there's a special angle to the story of the Zeewijk, and that is the discovery in the interval between the shipwreck and the departure of the longboat for Batavia, now Jakarta, that ultimately led to the rescue of the party on the mainland in Australia, when it was discovered that two young men, they're called boys in some of the stories, but one was 18 and one was 22, so they were really young men who had been caught having sex, and they were tried, convicted, sentenced to death, and ordered to be marooned on separate islands off the coast of Western Australia, near Gun Island, where the major party of the shipwreck were gathered. These two young men were not heard of after they were placed on the island, and the net result was that we must assume that they perished, and that would not have been difficult in the circumstances of isolation and lack of food and lack of water. But this was not a completely isolated event. As Drew Pettifer has pointed out, on the previous year, in the middle of the Atlantic, um, another sailor who had been convicted of the offence of sodomy was marooned on the isle, on Ascension Island, uh, and he had the bad manners to leave a diary, and the diary told of his deprivations and suffering uh, that followed his being left isolated on Ascension Island. Um, Sadly, his diary is full of reproach uh, for his dastardly crime, which, um, in the nature of things, was not the most serious offence that one could imagine, but it was regarded as abominable, and so abominable that the crime could not even be described or mentioned amongst civilized people. That's what Blackstone, the legal writer, wrote of it. And so, for their acts, which today would be of a relatively insignificant and indeed unimportant character, these three young people from the Netherlands, or what was then the United Netherlands States, were marooned and left to die. You've got to have an awful lot of hatred of people to inflict that sort of punishment on another human being, and just to leave them effectively in the middle of nowhere. But the interesting point that Drew Pettifer makes is that, um, in fact, this may well be the first trial, certainly the first trial in the Netherlands lexicon, and before any trial was conducted by the British on the mainland of Australia, that was conducted, and it was conducted for an anti-homosexual offence that was part of the laws of the Netherlands as then existing. And that is a good reason why we should reflect upon uh, the the crimes that were prosecuted against the young men and the terrible punishment that was inflicted upon them. The British Empire um, left the legacy of the sodomy offence in all of the territories where the Union Jack ever flew. In fact, it had three codes, criminal codes, for the purpose of stating what the criminal law would be in all British territories. Um, those codes were developed by three very fine lawyers, Thomas Babington Macaulay, James Fitzjames Stephen, and Samuel Griffith. Samuel Griffith was the first Chief Justice of the High Court of Australia, having earlier been, before Federation, the Chief Justice, and earlier still the Premier of the colony of Queensland. But he wrote a great criminal code which is in force to this day in Western Australia and in Queensland and substantially in the Northern Territory. Um, in other parts of Australia, the common law, or a mixture of the statute and common law, um, are in place in lieu of a code. But in Western Australia, the state adopted the Griffith Code, and like the Macaulay Code and the Stephen Code, it contained a provision imposing extremely severe punishment for sodomy. And that punishment originally was the punishment of death, just as had been imposed on the young sailors who were in the service of the East India Company. But the penalty of death was subsequently changed to extremely long periods of imprisonment, and that was the penal code of Western Australia that was in force for most of the last century. Towards the end of that century, steps were taken to try to get rid of the criminal offence against homosexual sexual conduct in private and between adults. And a statute was introduced in 1989 called the Law Reform Decriminalisation of Sodomy Act of 1989. And that law was introduced into the Parliament of Western Australia, and it provided that changes would be made to the provisions that Sir Samuel Griffith had bequeathed to the good people of Queensland, Western Australia, and the Northern Territory, rather similar to the statutory provisions in other states of Australia, including New South Wales, where I studied law. But there was a particularly nasty provision in the Western Australian Reform Statute. It's not very often you see a really nasty provision in a Reform Statute. If they want to be nasty, they simply don't enact the statute. But in Western Australia, they enacted the statute, but the representatives of the people of Western Australia in 1989, so we're not talking of a long time back, this is 30 years back, they enacted the following provision through the lower and upper house of the Parliament of Western Australia. Quote, whereas the Parliament does not believe that sexual acts between consenting adults in private ought to be regulated by the criminal law. So far, so good. And whereas the Parliament disapproves of sexual relations between persons of the same sex. And whereas the Parliament disapproves of the promotion or encouragement of homosexual behaviour. And whereas the Parliament does not by its act in removing any criminal penalty for sexual acts in private between persons of the same sex, wish to create a change in community attitude to homosexual behaviour. And whereas in particular, the Parliament disapproves of persons with care, supervision or authority over young persons, urging them to adopt homosexuality as a lifestyle, and disapproves of instrumentalities of the state so doing. And then there are the provisions for the reform of the criminal code, deleting the criminal punishment for homosexual acts. Rarely must a parliament have had such a sense of legislative indigestion when it presented a bill for enactment that it expressed so many times over its extreme distaste for what it was doing, indeed its reluctance to be doing it, and its concern that doing it might be misunderstood. This was something being done very, very reluctantly. And that was the provision by which in Western Australia, the law was changed in 1989. Now, my visit to the University of Western Australia in the 1990s and then in the first decade of the new century was the time when I saw the rainbow flag flying at the University of Western Australia. So that goes to show how very close to the enactment of this horrible legislation was the action of the Council and the Vice Chancellor of the University of Western Australia to fly the rainbow flag anyway and to send out its signals for those who were entering into its space. So that was the law that was originally enacted in Western Australia, and it took a long time for further laws to be enacted that have changed things in WA and in other parts of Australia. In fact, the changes that occurred began in none of the English-speaking countries. They began in France. In 1793, a meeting of the Estates General during the time of the French Revolution decided that it would repeal the old royal provisions in the criminal law of royal France that impose penalties on the crime of sodomy. And that led to a change in the French Penal Code, which was introduced by Napoleon in 1810, which Napoleon rightly said would probably last a whole lot longer than his battles and victories. The Penal Code of France profoundly influenced the criminal laws of Germany and many other European states. Through them, it influenced greatly the penal law of imperial and post-imperial Russia. And through that, it influenced the laws of China and Japan and many countries of Asia. And so in many of the countries of our world that were not blessed with British rule, they didn't have the provisions similar to those in the Griffith Code, the Macaulay Code, and the statutes that were enacted for the British Empire. They just didn't have those laws. But everywhere the Union Jack flew, they got the criminal law against homosexual conduct. This led to movements in England originally to get rid of those laws. Those movements were originally propounded by Jeremy Bentham in 1820 and followed up by J.S. Mill, but it was a slow process, slow indeed. Eventually, something happened, and this was considerably before Stonewall. Young people think everything has to happen in America, and that's the only way in which cultural change is achieved. But sometimes things can happen elsewhere, and so it was in the case of the sodomy offence and the criminal law against gays. In 1948, a very important researcher, Alfred Kinsey, began his research into the sexual conduct of the human male. Kinsey had been an expert in bees. His great expertise was as a zoologist, as they were called in those days. And that is what led him to examine the conduct of human beings, and that led to his two great books, Sexual Behavior in the Human Male and Sexual Behavior in the Human Female, 1948-53. At the time I first laid my hands on those books, I was aged 9 in the case of the first book, and 14 in the case of the second book. You can take it from me that it got a lot of headlines in the Daily Mirror and the other press in Australia at the time, because it was so shocking that somebody was actually researching and talking about sex. But the, the Kinsey reports and the subsequent work of Dr. Kinsey and of Evelyn Hooker, a great sexologist, led ultimately to steps in the United Kingdom Parliament for the reform of the criminal law. And the pathway to those steps was a royal commission. Sometimes good things come out of royal commissions, and this was the Wolfenden Royal Commission of 1956, chaired by Sir John Wolfenden, who was a vice chancellor. I would think he was probably a vice chancellor of the like of Alan Robson, because he was dedicated to science, and he just gathered the scientific evidence and said the criminalization of homosexuals is just fundamentally wrong in principle and wrong in effect and should be repealed. And that led in 1967 in the United Kingdom, well before Stonewall, to the Sexual Offences Act of 1967. And that act was the forerunner for the reforms of the law in relation to criminal laws in Australia. Most of the jurisdictions of Australia, though not Western Australia, as I have told you, or Queensland, which had a preamble rather similar to the Western Australian, not quite as offensive as the Western Australian, but it was of the same spirit. But in other parts of Australia, they simply repealed the old law. And so in the United Kingdom, and then in Canada, and then in South Australia in 1974, and then in New Zealand in 1986, and then in other parts of Australia, and finally in Tasmania in 1997, the old sodomy law was repealed. And that was a precondition to getting less hostility and less opprobrium that was evident in the statutory provisions that accompanied the change in the first instance in Western Australia. Since that time, the struggle in Australia and in other countries has been to follow through the logic of the step of removing the criminalisation of homosexuality and homosexual acts, and then secondly, to provide anti-discrimination laws to prevent discrimination against people on the grounds of their sexual orientation or gender identity, and then steps that were taken to secure the recognition of personal relationships of LGBTIQ people. Those steps were another difficult, painful, and needlessly protracted journey. Some of them were achieved substantially by court decisions, as the decision in the United States to recognize marriage equality in the Supreme Court's Obergefell decision achieved that. In other jurisdictions, such as Australia, the Republic of Ireland, and elsewhere, it was achieved by statutory provisions, but not without a real fight and obstacles placed in the way. The journey has by no means concluded. In many of the countries of the Commonwealth of Nations, which have inherited a criminal code from Macaulay or Stephen or Samuel Griffith. The Griffith Code, by the way, is in force in Nigeria. They opted to choose to follow the Samuel Griffith Code, and it's also in force in um, Ghana. So those codes are still applicable, and in some places there is very little change. Uh, Change has been achieved substantially by court decisions applying their Bill of Rights, their constitutional provisions, and this is the case in the great decision of 2018 in Johar against the Union of India, which struck down the Indian Penal Code, Section 377. And that has led to a series of cases that have sought to introduce similar reforms, sometimes successful, uh, but sometimes, as in Singapore, Uganda, Kenya, and Zambia, unsuccessful. And so the battle and the struggle goes on. And so the final question that I want to leave with this audience in reflecting upon thinking queerly is, why has this happened? Why did it last so long? Why was the battle and the struggle so protracted? Why were otherwise kindly and good and decent people guilty of language such as appeared in the Law Reform Decriminalisation of Sodomy Act 1989 of WA? Why was this so? Well, of course, a partial explanation is that the roots can be traced back to religious texts, and specifically to provisions in the case of Judaism, of Islam, and of Christianity, in the book of Genesis and in the book of Leviticus. And at least the interpretation that some have put on that is that God has commanded hate and death for LGBT people. Um, no one until quite recently paused to ask why God would have such an animosity to people who have simply followed their own nature, and why that would be so when what appears in nature ordinarily has a good reason or a reason for it. But whatever the reason, the fundamental lesson that these criminal laws were designed to instill in people was a hatred of difference, a hatred of the rule of variation that Charles Darwin taught was essential to the evolution of species. And the rule of variation in respect of sexual orientation and gender identity was something so intolerable that it couldn't even be mentioned. It was abominable. And the way in which it was policed was by inflicting upon people a feeling that they were unworthy, a feeling that they had broken God's commandment, and that they must therefore suffer, and above all, they must pretend that they were otherwise than they were. And this is uh, the um, the approach that is now falling apart as increasing research along the lines of Kinsey, Hooker, and other scientists have shown that sexual orientation and gender identity are not binary, but are on a scale, and within that scale there are divergencies, and this is just an aspect of natural variation. And if you've got a problem with it, you should take an aspirin and get over your problem and not inflict self-hate and denigration upon people who are LGBTIQ. Looking at the events in Australia at the moment, um, and at the events concerning human sexuality, I saw today that the former Senator Cory Bernardi has asked whether or not there is um, going to be an investigation by federal parliament into the sexuality of LGBT people. Why pick on straight people only? And this is all part of the attitude of dislike, distaste, and objection to difference. It affects Indigenous people. It affects women for being different. It affects people of different races. It affects people of various disabilities or attributes, and it is contrary to fundamental rights, and it is the duty of all civilized people to change it. And that is what we should do when we think queerly.
Thank you so much, Michael. That was really fantastic to listen to. We have about 25 minutes for discussion now. So I might start with a few questions for you, if you don't mind, then we can open up to the floor. You covered a lot of terrain there, so I think I might start with thinking about how you mentioned how sodomy was illegal until 1989 in Western Australia and in many other Australian states until the 80s and even 90s. It does feel like we've come a long way in the last 30 years, but I'm just thinking many of those early changes were about removing criminalisation, which could be said to be quite a low bar in terms of legal change. I'm wondering if you can elaborate on your reflections on the legal changes that have occurred over the past few decades and where that might leave us in terms of the pathway towards equality. And you're currently on mute.
The changes had to start with criminalisation, because whilst you had criminal laws, it was very difficult to make progress with anti-discrimination laws or relationship recognition or adoption by people who were LGBTIQ, or all the other changes that were necessary. For example, the big obstacle that existed during my judicial service in making a provision for my long-term partner, Johan van Vloten, to enjoy the Judicial Pensions Act benefits. That was something which during the 1990s, when my old friend Darryl Williams from NUAUS time was the Federal Attorney General, the proposition was put up that those sections of the Act should be changed to permit a same-sex couple to enjoy the same benefits as opposite-sex spouses and later opposite-sex de facto spouses. Those reforms had been changed, but Darryl Williams didn't agree with that. He said that is not government policy. And then when he was replaced by Attorney General Ruddock, Attorney General Ruddock said this is not government policy and it won't be changed. It was in fact changed in the first 2 weeks of the Rudd government. 120 pieces of federal legislation were changed by legislation that was introduced into the federal parliament by the new government, and the opposition, then led by Brendan Nelson, supported the changes. So I was left wondering, well, why did they present such an obstacle if it could so suddenly, within the space of the election period and 2 weeks, changed to no opposition. So, but it was necessary to change the criminal law first. Neville Wran, the Premier of New South Wales, didn't think it was absolutely necessary, and he enacted anti-discrimination law that forbade various forms of discrimination on the grounds of sexuality, but they were in place at the same time as the criminal law provided for the punishment of people for same-sex, adult, private, consensual activity. So there was a disparity between what the criminal law was saying and what the anti-discrimination law was saying. But fundamentally, you had to get rid of the criminal law. And we shouldn't think that issue is over in the world. It's not over. In most of the countries of the Commonwealth of Nations, they still have the same horrible old laws that we had. They haven't even, maybe we should export to them the preamble that was used in the Queensland legislation, if that would make them feel better, so that they could enact the legislation, but under protest. But you see, the clue to the objection is expressed in that preambular statement, which says, and whereas in particular, the Parliament disapproves of persons with care, supervision or authority over young persons, urging them to adopt homosexuality as a lifestyle. The contention that sexual orientation and gender identity are a lifestyle is such an unscientific statement, and it has to be dealt with very firmly, I'm afraid. But it still exists. I'm afraid it's something that exists in a lot of religious circles. They will go on referring to homosexuality as a lifestyle. Well, it's not a lifestyle. Whilst people were mesmerized by the lifestyle, I've even heard very intelligent judges using the word lifestyle. So this wasn't something that was only used by ignoramuses. It was used by people who heard in religious circles one's sexual orientation used as a lifestyle, like collecting stamps or something of the same. Anyway, reflecting on the change that has occurred, I think we have to be aware that in the countries of our neighbourhood, where there are many countries that still have the criminal law, we have to be of support and help to them in changing the old criminal laws which we donated to them. And this is partly done by worthy visits by learned lawyers and social scientists, and not all of them gay by any means, simply rational people. But it can also be done by thinking queerly and by people being honest and open about their sexual orientation. In some countries, it is extremely dangerous to be open and honest about homosexuality or transgender status. And those countries can inflict terrible wounds and punishment on people.
That's okay. I might follow up what you were just saying there as well, and thinking about more recent legal changes that have happened, such as the changes towards marriage equality. I know you married your longtime partner, Johan, you mentioned earlier, on the 50th anniversary of the night you met in 1969. How significant do you think the marriage equality changes were legally and socially for us here in Australia?
I think every step that is taken to normalization and acceptance makes it hard to go backwards. And I therefore think that, and research polls that are conducted in communities show that people often don't want to go back and re-argue those matters. Sounds like the cicadas have come early.
Perhaps.
I think we mustn't be content with addressing the issues only in Australia. And part of
They are talking.
part of the solution is by people who are LGBTIQ, where it is safe and appropriate to do so, being open and confronting the demons. I believe this is the way in which, to a large extent, we in Australia have overcome the demon of the yellow peril by actually meeting neighbours who are Asian Australians or African Australians or people of different races, different skin colour. Once you meet them, you realise how irrational hatred on the basis of some attribute of nature is. And that is how we have made progress in Australia on race. And it's how we will have to go on making progress on other features of human diversity, including sexual orientation and gender identity. And I think it is a bigger challenge on the issue of gender identity than it is on the basis of sexual orientation, which is more familiar to the public now than is gender identity. That is a big challenge, as President Trump found. Trump was not particularly hostile to gays, but he did a number of things in relation to transgender people in schools and in the military that were hostile. And the way to change that is for people to get to know transgender people and to get to know their journey in life. And knowledge is power, and it changes people's attitudes.
That's a really interesting point. I was actually going to ask you whether you thought the connection between law and politics and our social experience, for example, how that might influence the way change comes about. I'm thinking in particular how law and political will can sometimes trail the thoughts of the people. As you say, once people are familiar with certain minority groups, they can often lead the legal and political positions. I'm thinking, for example, of the many years of polls that showed majority support for marriage equality before we got there in Australia, among many other things. I'm wondering if you have thoughts about those perceived gaps and how the social might interrelate with the legal and the political.
I do think it's true that in Australia, we lag behind popular acceptance of change. That seems to have been demonstrated by the marriage equality debates, where it was fairly clear for a significant time that the majority were quite comfortable over the issue. And that was a reason why my partner Johan and I were not favourable to the plebiscite, because it was interposing on the path of an equality provision in the law, an impediment that had not been interposed in other cases, and we objected to it. My partner Johan grew up in the Netherlands under occupation, and though he was only a little boy at the time, the post-war dialogue in the Netherlands about those who had cooperated with the occupying force and those who had not, and often paid a price, was extremely bitter. We don't, if you're not connected to someone who lived through that experience, you don't really fully know it. But Johan continually said, as an Australian citizen, I object to something being put as a barrier in the path of my equality. And that's why originally we said we would not vote, we would not take part in the plebiscite. But eventually we changed our minds and thought, well, we shouldn't give haters a free kick. And so we did vote. But it was an unfortunate precedent and a bad process, but it led to a happy outcome. And as you have said, we got married on exactly the 50th anniversary, the day of our meeting, and indeed virtually the hour of our meeting 50 years later. And if you could conceive something that was less threatening to other people and to society, well, let me know about it, because I don't think we were a big threat to anybody.
I wonder if you have any questions from the floor at University of Western Australia at the moment. We'll see if we can open it up, and hopefully the technical abilities allow that to happen. Do we have questions from people in the audience? No, not at the moment. That's fine. I have plenty more questions for you, Michael, to use up the last few minutes we have. I suppose a key question is where you might see future challenges for the LGBTIQ plus community, particularly in relation to the law and social change. I'm wondering whether it might be in the space of conversion therapy, or I know that the homosexual advance defence in South Australia is still being repealed, or religious exemptions, for example, for anti-discrimination laws, or are there others that we need to be aware of as well?
Most of these are bits and pieces, and the major battle in relation to criminal laws, in relation to anti-discrimination laws, and in relation to relationship recognition, those battles have been fought and won. But there are other bits and pieces. I think if the so-called religious freedom bill, which has been introduced into federal parliament by the federal attorney general, is pursued, then that is going to be a very significant test case, I think. And it's going to be necessary to ensure that we don't permit people in the name of their religious beliefs to reignite animosity and hatred towards LGBT people, trying to force them back into the silence of self-denigration and humiliation. I don't see necessarily an easy problem to solve, but the bottom line is it mustn't be permitted in the name of religion to humiliate people, to allow people to be thrown out of schools or thrown out of employment because of their sexual orientation. And this is going to be a test for us. And I believe we should be quite firm on that test. It's interesting that I think I heard the Prime Minister that no one believes that a child at a religious school should be thrown out of the school because of their sexual orientation or gender identity. I think Mr. Morrison, who's got a fairly good weather vane for where public opinion exists on particular issues, as is demonstrated in the COVID-19 crisis, which I believe he's handled very well. I think that if that is his position, well, I welcome that position. But I know that there are some people who want to deny the existence of LGBTIQ children and who say, well, we don't have anybody at our school who is gay. And that, alas, is because of the hostility that is exhibited towards gay people in many schools of a religious persuasion. So somehow there has to be a reconciliation of people's right to hold their religious beliefs, but not to proclaim them in a way that is going to denigrate and humiliate and take away the freedoms of others. I once gave a series of lectures in Calcutta, and it was called The Right to Swing My Arm. And it goes back to a statement which is often expressed in philosophy, that my right to swing my arm finishes when I knock the chin of someone else. And likewise, the right to have one's beliefs and express those beliefs and act on those beliefs reach a limit when they begin to hit the rights of others who are adversely affected by them. And I think that's what we've got to try to persuade the federal parliament should be the proper approach to the interface of the advance of LGBTIQ rights and the protection in the temple of religious opinion and religious rights.
Thank you, Mark. That's a wonderful point to end on, actually. Can I just ask everyone to please thank Michael Kirby for such a wonderful and insightful presentation today?